Good evening. Who we got? Michael, good evening. Daniel, good evening. Jason, good evening. Can you hear me?
Yeah, I can hear you.
Good evening. Debbie, good evening. We've got a lot of people here already. Okay, 7 o'clock. Hello, Jane.
Hello.
Welcome to the third tutorial. The first tutorial was just on introduction, and the second one last week was the first of the 6 or so elements that we look at in determining whether there's a contract, and that was on capacity. Today will be the second element, which will be intention. Now, everyone does it slightly differently. We've got 6 issues here to look at. Capacity, intention, agreement, consideration, certainty, and completeness. You look at some of the textbooks that do it slightly different. At the end of the day, it's all basically the same. So I'm in Melbourne. It's terribly hot last few days. It reminded me I used to live in the Philippines. Now the Philippines were ruled by the Spanish for 350 years, and then there was 100 years with Americans. So it's a mixture of laws. And I was just thinking while I was waiting, how you have to be careful when you deal between countries, or if you go to another country, the laws may differ. Now, in essence, if you know your history, the UK, the English Empire, British Empire expanded. I may have said this before, I can't remember because I do so much work, I can't remember who I talk to anymore. But the British Empire expanded, to United States, Canada, India, Pakistan, and there's Bangladesh from memory, there's Hong Kong, Singapore, Malaysia, New Guinea, Fiji, Australia, New Zealand, South Africa, and I'm sure there's a lot of other little places. So you'll find a lot of the law very similar. And then there's varieties, like in the Philippines, where I have a bit of Spanish law and stuff like that. And American law has begun to diverge from English law, but ultimately they're all basically the same. There's this contract, and part of it is capacity, which we looked at last time. And obviously intention is critical. The example I've been giving you for a couple of weeks now is a little boy comes to me and says, Daddy, would you mind if I clean the room up, would you take me to the cinema? And I'd say yes. Now, what would happen there if I didn't? Someone quickly?
Nothing.
Go on, Michael.
Nothing would happen.
In what way? Explain.
Well, he could only be annoyed at you as a parent. He can't be annoyed. He can't take you to court because it's no intention to make a commercial agreement or legal.
Yeah. And then when we go to the other end about commercial agreements, and I note from the lecture and from the materials and stuff, we actually expect them to be enforceable, and irrespective of the size. Now, I'm not picking on fast food or anything like that because it's just the first thing that came to my mind. I go and buy some chips for $2 and I get sick. Now, am I going to have a legal action against them? Yes, because the whole thing was intended to be legally bound. That if I get sick, I have an action against them. Okay, so with all of that, let's start tonight. And I was thinking, what's the best way to do this? And I thought if I was a student listening to this, and later on sometimes you want to listen to it twice, what's the best way? How would I like? And I thought to myself, you know what I really should do is I should skim over the materials, the study guide, just quickly go through that and just reinforce a few points, and then spend some time on the problem, and then talk around the issues, because I found in the past when you're a bit more engaged, it's easier to listen, easier to learn, and the engagement comes out of listening to the case studies and the issues there. So that's what I'm going to do, and so I'm going to work now from the study guide. And of course, I'm not going to read from it, but it's going to be a refresher from my memory. And we've got a number of cases, and I'd like to go through those cases because, look, ultimately, at the end of the day, um, we need to refer to some law. Now, contract law in Australia and basically in the British Empire and ex-British Empire is common law. Now, common law is this book here. Can you see this? That's Commonwealth Law Reports, Volume 99, 1957-58. There may or may not be a contract case in there, and that makes good law. Now, you would have studied a subject similar to Introduction to Law, and you know how all this stuff works. It's interesting, though, I do a bit of work overseas in India and in Malaysia, and both of those have a Contracts Act. You have the Indian Contracts Act 1872, I think, and the Malaysian Contracts Act. They have, and where they specify, and it's actually really good. And I thought, wow, we should have that here, because there's a specification of rule after rule after rule. And if you're a shopkeeper here or a business person here, how would you know these contract laws? You'd have to go to a textbook. And even then, there's interpretation of different people. Okay, so enough of that, because we're not here for that, but we really are here to go through the law of contract. But I wanted to give you a bit of background, just so you get a feel of it, because most of you will, one way or the other, be involved with international transactions. It's just the way life works. Outsourcing is just a fact of life now. Generally speaking, what happens is that we in Australia, we buy from places like India, China, Philippines, Vietnam, Indonesia, and maybe sometimes in South America and obviously Europe, UK and USA. And we need to be very aware of the law we're going to use. And often we do that, we specify that in the contract. All right, so what I wanted to start off with is on page 5, there was the key concept of, and sorry, the heading number 2, key concept, subjective and objective tests. So can someone tell me the difference between subjective and objective tests? And I'd say this to you if you're in one of my classes, because I run courses for executives. I had one yesterday, I've got 2 days next week. I usually take some chocolates to get people talking. So regrettably, I can't give you any today. But would someone like to tell me the difference between a subjective and objective test? Anyone?
So a subjective test would consider what the actual party was doing and thinking at the time.
Yep.
And an objective test takes into account what a reasonable person would do in the same circumstances.
That's terrific. You get a chocolate for that. I owe you one.
Oh, you have to post it to Gold Coast.
What was that, sorry?
I said you'll have to post it to Gold Coast.
I'm there next week doing some work, So, yeah, actually, my next class, I have to take my PC with me. Gee, I'm glad you reminded me. I'll have to make sure it works, because I'm there on Thursday, Friday on this job. Now, that's very good, because as the notes say, subjective and objective will be around for the rest of your course. See, the British law, which we've inherited, is all about fairness and equity. And I think I may have mentioned, did I mention to you last time about Lady Justice, how she has the blindfold and the sword and the scales? Did I talk to you about that? Well, anyway, she symbolises, her name is Lady Justice, Justitia. Yeah, I think I remember saying it to you last time. And she symbolises fairness. And the whole thing about fairness is that we don't really look at the subjective issues in what the person was thinking about at the time. What would the reasonable person from the outside be looking at? Because then it's a more balanced view, more fair view, because the parties could later on say, oh, well, I intended this, which could be a complete lie. So, okay, so we've covered topic number 2, the key concepts, subjective versus objective. The next one is rebuttable presumptions. Who would like to have a go at that? What's a rebuttable presumption? Well, first of all, it's in better order would be, what is a presumption in the first place? Anyone? No one? All your names have got the... Who's talking to this? Jason, is it again?
I just have a stab at this, but isn't a presumption what the court applies to a certain circumstance?
Yeah, it's not a rule. it's a rule of thumb. You know, it's not a hard and fast rule. It's a rule of thumb. And in fact, in Genesis, I can't even pronounce it. In Genesis case, the one with the Ermogenesis case, the High Court even said, "Oh, you know, we don't know whether presumption is a good word to use." But look, just keep it simple. The usual situation would be such and such. It's not guaranteed, and you can bring evidence to go against that, which means rebuttable. Okay. Now, for some reason, I see beside all your names the microphone with a line through it, including yours, Jason. But you are talking. So Michael, Daniel, Jade, and Debbie, if you want to say something, feel free to speak. Okay. So let's go to the next one now. Part 4: the test for intention to create legal relations. Okay. So they say there are three tests. And the first one is step number 1: is the agreement social or commercial? Okay, so how would you know if it's social or commercial? Someone?
Or between family members, or is there a contract? Basically, coming down to the intent. But
good, Michael. Thank you. And I like your boat. And how's it going with your boat? You're suing someone, aren't you? Or they're suing you?
Yeah, we are. It's such a small case, you don't really use a precedence, as I'm learning, but it's slowly getting there. We've tied in the owner, so then we're going to hopefully have a meeting before Christmas and then them concede, because they've broken about 15 different, or about 6 different consumer laws. So,
well, what you can do is maybe give a 5-minute presentation once, as long as it's relevant to the class here.
Yes.
About the issues, and what we might do is get through the semester. But if you just remind me, because it's always good to have actual cases, you know, and you can take the spot for 5 or so minutes.
Yeah.
Now, what happened in the case of Balfour and Balfour, and who won the case? Anyone?
That's the one with the parents coming from England. No, that's Wakeling versus
That's
Ripley.
the guy, Salon.
Yeah.
Now, let me just take a step back and interrupt you for a second.
Yeah.
If you want to pass this subject, got to know your cases. When I was law school many years ago, I used to have a card system. I used to write the name of the case on the card, and then very brief facts, because the law is all about what the judge said. Unlike what I said to you before, in India and in Malaysia, where they have a set of rules, 1, 2, 3, 4. Rule number 47 says this. Now, you've got to know your cases. Now, you won't be punished if you don't know the name of the case. If you say, oh, the man who came from England to be with his daughter-in-law, etc., we all know what the case is. But if you can write the name down, it's better, you know. And as it's not an examination, it's more of a open book. It's probably more expected of you. But I'm just saying, for the future, because this is a law course, you need to know your cases. Okay, this and torts are the real subjects you need to know your cases. Now, so Balfour and Balfour is the civil servant who went to Ceylon and his wife stayed behind. What were the rest of the facts?
He promised her to pay her a monthly amount of £30 per month.
Yep.
In maintenance, which is, again, it's a social arrangement because it's husband to wife.
Yeah, and these begin to build up a body of law. And so you just got to be familiar with them. Now, at the beginning of your guide here, your study guide, there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases. You need to know each. And what I've done is I've just put a single line. I'll tell you what, beside Balfour and Balfour, I put page number 7 so I can find it, in case someone asks me. Husband went to Ceylon, wife stays in UK, promised £30 per month. He reneged, held to be social, therefore a social agreement, and therefore no intent, and therefore not binding, and therefore can't sue. Okay, and that's all you need to know. Okay, and they become authorities because you base your law on that. Okay, so that's Balfour and Balfour, and that goes to it's more of a social domestic agreement. And like someone mentioned before, I think it was maybe Jason or someone spoke before about my little boy. He can't sue me because it's not a commercial deal. Okay, so in the commercial agreement, it has a characteristics of a business transaction. Now, a leading case there is Edwards and Skyways. Now, can someone give me what happened in Edwards and Skyways?
Where the pilots were becoming redundant.
Yeah.
And they signed an agreement to leave, like I think it's ex gratia payment, and then they reneged on it and they had to sue them to get their payment. So the pilot sued Skyways Limited.
So the pilot sued his ex-employer.
Correct.
And what did the court say?
That it is a business agreement. Agreement is a business relation, so it's not social or domestic. So they must pay. I think that this is. Yeah, they got them to sign it, then they reneged on it.
Yeah.
They're now not employees anymore. So. Yeah,
and my recollection is, whilst it was rather informal, the whole thing, the fact is it was an employer-employee relationship, which actually, intuitively, it's business. Yes. I run a business and I have someone working for me. It's a business transaction. I don't pay them. Well, they're not there because they love me or anything like that. They're there to make a bit of cash. So that's the usual there. Now, so once again, the first step was we got to work out whether it's a social or domestic agreement. Now, you can see what we're doing now. We're leading up to the problem later on with the three people in their diner, and you need to think these things through. Now, the second thing is apply the relevant presumption. So if we have a social agreement, what is the relevant presumption there?
It's not legally binding.
It's not legally binding, Now, what that means is that, like with the little boy and like with Balfour and Balfour, it's a family domestic situation. The law doesn't want to. How far does the law go? I mean, the law sort of stops at the gate of the commercial deal and doesn't go in further into the social domestic agreements, because do you sue? If I went, one of you came to Melbourne and looked me up and we went and I said, I'll buy you a drink and we'll have a bit of chat about the course, and I didn't, can you sue me? All that sort of stuff. So it doesn't want to get involved in all that sort of stuff. So the next one is I think the relevant presumption for social is that the parties are presumed not to intend to be legally bound. So if something goes wrong, they're going to sue. But the other one with the commercial, which is a very strong presumption, because we do expect when we go into business that if someone doesn't do as they're supposed to do, we're going to sue them. Either the food is not good and injures us, or I bought a TV which is not fit for purpose, or you build a factory for me which doesn't work, etc., etc. The whole of the commercial, our whole economic system is built upon contracts, because if we didn't have contracts, the whole of the economic world would fall apart. So it's there, and it's hard to get out of. Now, step number 3, rebutting the presumptions. Okay, so rebutting means you've got to give some sort of evidence to show that what the usual situation with social isn't the case. So can someone give me an example when you can rebut the presumption against the social, the social presumption is they're not going to be intending to be bound. But can someone give me an example of how you can rebut that? Daniel, that's good.
In attention for disability.
Sorry, it was a bit hard to hear. Say that again, please.
Sorry, just by adding a clause stating that there's an attention for disability.
Yeah. So it's a social domestic, and we now want to overcome that and make it quite clear. So you and I are brothers. I buy your car, and there's a good chance it'll be seen as a social and domestic situation. The parties won't be bound. But if we go out of our way and we make a clause in the contract, particularly if it's written, when you write a contract, it pushes you towards the commercial area. It's not conclusive because I can write something down with my brother. But anyway, so I lost train of my thought. What were you saying, Daniel? Say it again.
Like if you put a clause in there that you are intended to be
Yeah,
legally bound by it, then you really are saying that you are.
Yeah. And also, if the thing is so damn obvious that it's a business. So I think I gave the example previously of Kerry Packer and his son. Now, if they're dealing with large transactions of share portfolios and purchase of properties and stuff like that from one country to another, although they're related, there is a strong feel of business about it, right? And out of prudence, if they did not want it to be legally binding, what would they do?
They would put in a honor clause.
Wonderful. And can you remember the case which relates to honor clauses?
Not off the top of my head, no.
Can you remember the facts of the case? Because if you were one of my, if I was marking your examination, and just in the spur of it, in the heat of the moment, you forgot the name of the case, could you remember the facts of one of the cases on honor clauses?
No.
Now, there are two cases there. One was the Pools case, which is Jones and Vernon Pools. We'll come to that shortly. And the other one was Rose, Frank and Compton, okay? But the fact is, you would have passed the question because you said the most important words, honor clause, okay? So, let's keep on going. So rebutting the presumptions, as we said before, is that you need to go out of your way to show that's not the case. So with social domestic, you've got to actually perhaps state that it's binding. And I'm repeating myself now, and if it's a commercial case, you say, we don't want to be bound. And Jones and Vernon Pools, can someone else give me the quick facts of Jones and Vernon Pools? Anyone?
Gambling syndicate, sort of,
Good.
and basically stating that they can gamble, but they're not going to be legally bound.
Yeah. Look, and I remember doing that in law school years ago, but I just thought to myself, I mean, that's just totally crazy. If I got all the effort of putting a ticket in, for tax lotto or something like that, and on the back of the ticket they say, oh, we're not going to be legally bound. Well, it's a bit silly, but let's leave that aside. The issue here is on them having a clause stating they won't be bound. And what did the court find?
They found that arrangements, agreements, and transactions are binding in honour only. Yeah, and so in other words, can you sue on that? No. Well, you can't sue successfully. Well done. I like that. Good thinking, So when you do a question, if you have the time, follow it through and just make it quite clear as to who you think will win. When you say, "Oh, it's an honour," I'm not mentioning what you said. I'm just speaking generally now. Do your question, and then you say, "I feel such and such would win because of this reason." And that's Jones and Vernon Pools, and that's a really good case to quote because clearly the parties were in a business transaction, but it was taken out of the realm of business transaction, put into the realm of basically social and domestic, that it's not legally binding by the insertion of that clause. And so whenever you see a clause like that, you've got to be a little bit careful. Now, can someone tell me about the next case, the Rose and Frank and Compton brothers?
I think this one was a case where one party was in the US and one was British.
Good.
And they had on a clause contract in regards to paper. I want to say paper.
Carbon paper.
And I can't recall any further, actually.
Okay, that's good. Listen, the fact is that you recall that you'd get marks because now what happened, it's really straightforward. It's very, very similar to Jones and Vernon Pools. The English company and the American company signed a contract. Ordinarily, that would be binding, like a zillion other commercial contracts. However, they put what's called a honor clause. Was it honor clause? They put this clause in where they say, you know, we love and cherish you, but we won't sue you and things like that. And the court held that was binding, okay? There was a little bit of extra to it because there were individual contracts and they did not have that clause in it. Therefore, it was not held to be part of those further individual ones. But in essence, if you quote Jones and Vernon Pools, Rose, Frank and Compton, you're right. And so I go back. So every class, and you've got about 10, 12 weeks. You've got a skills week, but so let's say there's 12 weeks and there's about 10 cases. You see how I did in the old days. I used to have a card with it. You do it your own way, but you really need to know them. And in fact, you don't even need to memorize them because nowadays you won't have closed book exams. You'll take your materials, or you have your materials in front of you while you do your essays, etc. But you need to have them nearby so you can, when you answer a question, you can actually quote a case, because these rules don't come from just thin air. They come from a case. The case provides you the authority. And again, I don't want to do too much on introduction to law and legal process type material because you would have done it elsewhere. So therefore, that sets everything up. And then after that, on the fifth paragraph, we had the difficult middle ground, commercial agreements between social relations. And that's where it gets difficult, that you have a friendship between people, but there's also, there's a commercial arrangement, or there's a family arrangement and there's also a commercial one. You know, how far do you go? So could someone tell me about the case of Rufus and Brewster, the 1971 South Australian case? Rufus and Brewster. Anyone remember that?
I think it was a family arrangement where the guy owned a restaurant and he drove a truck from Coober Pedy to South Australia, crashed the truck in the process, and then the family that owned the truck, who were related to him, I think it was like in law or whatever, sued for the repairs on the truck. And it was successful because they decided it was a commercial agreement, not a social agreement.
Yeah. Well, look, the facts are very, very similar to that. And the court said, I have no doubt that the learned special magistrate was right when he held the agreement between Mrs. Brewster and Mrs. Rufus created legal relationships between the parties. It is true that the appellant is a son-in-law, but they were conducting separate businesses at such and such. The whole setting of the arrangement is commercial rather than social domestic. That's what the judge found, because there was an agreement. He was being paid to bring the truck from Adelaide to Coober Pedy, and he smashed it up on the way, and he was sued for breach of contract. You promised to bring the car back. You didn't bring it. Oh, you promised to bring the car back. An implied term is it will come back in good shape. It wasn't, and we're going to sue you. All that sort of stuff we'll talk about at a later stage. But what we need to talk about here is the middle ground between commercial agreements and social relations. Now, let me just read this out because it's important here. Notice how the court did not at any point stop to ask what the parties themselves intended. That's the subjective test. The only real question was how it looked from the outside to a reasonable observer. The court decided that a reasonable observer would consider the whole matter to be commercial rather than social or domestic, and as a result, the Brewsters were entitled to sue. So, Jason, you're right on that. So good on you. Okay. Now, what you'll find in the real world, a lot of cases are pretty borderline, because if they weren't borderline, they wouldn't have gone to court in the first place unless someone's an eccentric or had, or they wanted to prove a principle or something like that. Okay, so a lot of cases that you'll be involved in as solicitors are borderline, and the sort of stuff we're doing tonight is where you'll be, because it could go slightly here, it could go slightly there. All right. Any questions so far? Okay. Paragraph 6, a final case study, homogeneous. So can someone give me the brief facts of that case and what happened? How the court held it. Okay, another South Australian case.
It's Greek Orthodox Church.
Okay, and what did it want?
It was working with other bodies, and they were working for him, and he did work for like 20 years.
Yeah.
He wanted some long-term service leave, and they wouldn't pay it.
Okay. That's okay. Look, I might be wrong on the facts. I might be wrong. They needed a bishop, and they looked around the world. It was one in the United States. They said, "Come on over. We'll take care of you. We'll pay you." And it's different from you or I working for an employer. When you come in, there's a senior religious person, and you have your devotees there. That's a different sort of relationship. So you could say there is a middle ground between the commercial, which is salary and wage, and social, because he was there in a pastoral way. And after X number of years, he left, and he wanted to have his employment, entitlements, as you or I would have. And what did the court hold?
He was entitled to long service leave payment.
Yeah, and using different words, the court held. Why did the court hold that?
That it was a legally binding commercial agreement, basically.
It was a commercial agreement. Because it was a commercial agreement which hadn't been rebutted, therefore he is entitled to all which he or other people would be entitled to, having worked for such amount of time. Okay? Now, in the real world, what we do, I mean, this is a real case too, but I'm saying is that you have other documents. You'd look at, did he put tax returns in? What did he put in those tax returns, etc., etc. You know, I was just reading a case the other day. There was this bikie saying that he was ripped off by someone in this parlour, and he was saying that he was an employee, and they said he was just I don't know what they said he was. You have to go back to documentary evidence, because the whole case is about evidence. Okay, so in Homogeneous's case, it was seen to be more commercial than social, and there was no rebuttal, and therefore he would be entitled to sue. Okay, and it's not nice to see those things happen in communities like that. All right. Now, the 7th paragraph here is special agreements, and the first one is government agreements. And can someone tell me what the situation is with government? What's the situation with government? Are they bound or not?
Okay. If anyone else want to go?
Yeah, it's someone else. Jade, Debbie, anyone else? Let me unclick someone to see whether it helps. Doesn't help. Unmute. Jade or Debbie, you want to go? Just give it a go. Look, here, it doesn't matter whether you get it right or wrong. It doesn't matter to me. This is a good time to learn. Anyone?
So I think it's along the lines of, if the government states policies, then they're not going to be bound by them. But if the government makes business relations while they're governing, then it's a commercial.
Good boy. Give me your hand. I'll put a nice chocolate in your hand for that. Well done. Now, this is actually very important. I recently wrote a paper, a while back I wrote a paper on the new small business unfair contract terms legislation, one of which is that you're going to be super careful when a government is involved in all of this, because will the government be bound? And that's exactly the sort of thing you need to look at with it, because for example, and we haven't studied it yet, but misleading deceptive conduct. The government, let's say the Defence Department, says, well, we're not bound by misleading deceptive laws because we're the government. So just keep it really straightforward and simple. If the government or a state government or an agency or a company owned by them is more in the nature of a commercial type arrangement, and they enter into a contract, they will be bound. Okay, like everyone else. It's in this situation when we're talking about contracts. If one of the pollies says, I will give you all $1,000 if you vote for me, and we won't vote for them, and they don't give it, we can't really sue them. So that's government. I'll just read this last sentence out. It's just above 7.2. So when dealing with government as a party, we must carefully consider whether the government is acting as a normal commercial party with commercial interest in the agreement, or whether it's just making and administering policy. And that's from the contractual viewpoint. I gave you some other legislation before. That will go in more detail later on, so don't worry about that. Now, the other thing is that the author slipped in preliminary agreements. This is a difficult area of all the work we've done so far. It's probably the most difficult. What is a preliminary agreement here? And 2 chocolates to anyone who gets this one. This is a hard one.
Preliminary agreements where 2 companies make a pre-contractual agreement stating that they were going to work together and proceed further down towards a contract that may continue to do more work to get there.
Good boy, that's great. What about there was a famous case, Masters and Cameron. What was that all about? It's a major case, high court case. I use it in my. I teach executives all the time contracts and managing contracts and stuff like that. So. On a regular basis, I use Masters and Cameron.
It's about purchasing, and then they withdrew. I don't remember a lot about that.
Yeah.
Government, was it? No.
Yeah, there were 2 farmers, and one farmer says to the other, you want to sell your land. In essence, they wrote a contract. The vendor and the purchaser agreed to terms of the sale, and they set out an agreement for the sale to proceed subject to the preparation of a formal contract of sale in a form acceptable to the purchaser's solicitors. Okay, in a form acceptable to the purchaser's solicitors. And one of them pulled out, and no one knew whether the contract was binding or not. Okay, and I have that often with executives, because have you heard of a thing called a letter of intent? I suppose you've got to be in a
yes.
In the construction, if you're in the construction industry, you'll know it, and probably the IT industry. What happens is that, let me give you an example. The principal who's running who wants to build a big building goes to you, Jason, and says, look, can you do this job? You say, fine, you can do it. And just before you're about to start, something's gone wrong and you can't do it. Now, then they come to me and ask whether I can do it. And I say, yeah. Where's the contract? The contract's not finished. I don't want to start without a contract. Neither do you as the purchaser. You don't want to start without a contract. So what we do is we do a mini contract. Now, if a construction contract is normally 300 pages, a letter of intent might be 2 or 3 pages. Okay? So you've got to be really, really careful because when you think about it, 99% of the content has been removed, 1% of the content is left. The big question, we'll answer this through this term, is what do you keep and what don't you keep? Now, big thing is, will that contract be binding or not? That 3-page one. Remember, we just did a quickie contract because we don't want to start on a verbal, on a handshake. We want to start on some sort of document. And if you go to your notes, 7.2 on the bottom of page 14, it says, look, there's a couple of things you really need to look at. There are 4 things. The parties must have intended their agreement to have some sort of legal effect. So you need to have the builder and the owner both intending to have a legal effect. And you might look at correspondence to see what happened and what discussed. The second one, the parties must have reached agreement on all the important terms of the contract, and these must be sufficiently certain to be able to be enforced. So if I'm the contractor, the important terms would be obviously who the parties are, what the price is going to be, and what are they going to be doing. And we need to be pretty clear about those. Now, you'll note what I just read out to you. These must be sufficiently certain to be able to be enforced. You can't have something, build a building, or we will decide on the price later on. That's not acceptable. Okay. And I note in a couple of weeks' time, our sixth topic after consideration, the last one was certainty and completeness, because we need to be pretty clear and certain about what we need to do. Okay, so the third topic now is any conditions precedent must have been satisfied. So if you had to do something beforehand, it had to have occurred. So if I'm an employer and I say to you, Jade, Daniel, Jason, Debbie, etc., if I say to you, okay, I'll hire you. I know you've got your exams coming up. You pass your exams and you bring me a certificate showing that you got your law degree, I'll hire you. Okay, that is called a condition precedent. That condition, that hurdle must be overcome before the contract starts. So far, we've got three of them, one more to go. And the last one is the agreement must be in the proper form. Now, we haven't studied that yet. We'll study that later on because under the common law, every single contract could have been made verbally, can be made verbally. Okay, so buying a house, guarantees, insurance, buy and selling of intellectual property, all that stuff can be made verbally. Now, because there's a lot of fraud in some of these areas, particularly with land, you can allege Mrs. Kafup said this and they're there, and she agreed to go into an agreement with him. Now, there was so much fraud involved. In the 1660s, we had a statute called the Statute of Frauds, which has now been basically ossified. And so in plain English, it's basically the same thing. If you want to transfer an interest in land, there must be some sort of written note or memorandum. Okay, so a letter or some sort of evidence that you've agreed to it. It's got to be in writing to satisfy that. So let's go through them again. I enter into a preliminary agreement. It's an agreement now in anticipation of one later on. There are two agreements. We need to treat each of those separately and make sure that all the requirements of a contract for each of those have been considered. On pages 14 and 15, you've got the 4 points there. The first of the 4 points is that the parties must have intended their agreement to have legal effect. Okay, so you need to have a look at whether they intended. Secondly, they must have reached an agreement on all of the important terms of the contract and be sufficiently certain. Okay, so you can't have a wishy-washy thing, half thought out, won't be acceptable. The third one, if there's a condition precedent that you had to do something first, it must have occurred. And the fourth one is if there is a requirement, if there is one of the types of contracts where it has to be in writing, well, that must be in writing. Okay, so you might even leave the last two out if those don't apply. So the first one is they intended to be illegally to be binding, and they must have reached agreement. Okay, they have a preliminary agreement, and then you go to the next one. Okay, so I know that's difficult, and we put that to one side. Now we've got concluding summary. I think that's just a summary of bits and pieces. Now we've got our tutorial question, and I hope I haven't exhausted you by now. So let's start. Let me go through the facts. There are 6 paragraphs. And it's just, it's good if I've broken them into 6 different areas because the paragraphs neatly give you the facts. So we've got Katrina. She's got her own business. She's quite experienced. She's got a dress shop. Richard, again, has his own business. He's experienced also. He's got an old-fashioned vinyl records place, and he does repairs to jukeboxes. She starts buying records from him, and they get a bit friendly. They start talking, and she purchases a jukebox of him. And they stayed in touch for about a year, backwards and forwards. You know, basically, she purchased from him. That's the first paragraph. Second paragraph, they're having a chat, and they saw the similarities in their businesses, and they thought, "Oh, this is pretty good. We could do well." And this was about a year after they first met that they decided to go into business together. The third paragraph. They both realised, being experienced business people, it's going to be hard to work together, and they got a third person. They don't say the reason why, but reading between the lines, Emma used to run a cafe before having kids, and sometimes you have a third party because then it's 2 versus 1, so you can have a majority vote. If it's 1-on-1, it's difficult. And they decided to start up a 1950s diner. The fourth paragraph, the business did really well and made lots of profits, and gave spin-off to both Katrina and Richard. So they're both very happy. And Katrina and Richard, just like in Hollywood, fell in love. And to the music, they danced away. The fifth paragraph is, regrettably, the music stopped, and at the second anniversary, things weren't too happy. That Richard and Emma were really dark at Katrina because her business is booming, and they feel that she's not pulling her weight. Now, I've been around commercial things for a long, long time, and I can say to you that this is probably the biggest pitfall of running biggest reason for partnerships failing is because one thinks the other person's not doing enough. Or person A and person B. Person A does exactly the same amount of work as person B, but A has a better skill or whatever, and A brings in 80% of the income, and B brings in 20% of the income. And then A thinks, well, what in the hell am I doing here? You know, I'll get rid of this other guy, etc., etc. Tensions arise between Richard and Katrina, and then in the sixth paragraph, Richard and Emma come to us with a lawyer and ask for legal advice as how they can terminate the contract that they all signed when the diner was being first opened. Okay, so you get the facts there. Now, I mentioned last week or the week before, you've got to be really, really careful with the facts. It's if you ever drop a subject, in other words, fail a subject, don't do it because you haven't read the question properly. Do it because you've been partying non-stop, but don't do it because you haven't read it. So get the question and you read it a couple of times. First time, read it through. Second time, underline key aspects. And third time, make notes. And even then, I feel nervous after this because I haven't had a hand from anyone. I've just sort of gone through here to see how it goes. And it's actually quite involved, this one here. So the first question is, what presumption will the law apply in relation to the intention and create legal relations? And we're supposed to advise both Richard and Emma. Now, before we start, what is the problem of a lawyer, an accountant, or a professional advising two of the three partners? What potential problems you might have?
Individual advice?
Yeah, so there might be a conflict of interest. Got to be really, really careful because suddenly Emma might decide, well, she wants to have a go at Richard, or Richard have a go against her, and stuff like that. In that case, the lawyer has to perhaps bow out and suggest that Richard goes elsewhere and Emma goes elsewhere. Okay, so conflict of interest situations. I've seen it many times, and I've advised instructing solicitors to have a go at the accountant when the accountant was doing the work, accounting work for husband and wife for years, and then one of them, they decided to divorce, and the accountant, I've seen this countless times, goes with the partner, the spouse who's got the money. So if spouse A's got the money, they will work with spouse A to go against spouse B. Well, that's a definite conflict of interest.
Mm-hmm.
You've got to be careful. So I don't want to speak about that more because I need to stick to the contract law stuff because that's our jurisdiction here. Okay, so and I was thinking to myself, so what presumptions will the law apply in relation to their intention to create legal relationships? So the step number one, we go back a couple of, in our study guide, they gave us the 3 steps. Okay, the step number one, we have to work out whether it's social or business. Would someone like to have a go at that?
Well, it started as a business.
Yeah. And do you feel there is a potential for an argument that it's not a business?
No.
I thought the same thing too. I thought actually it was a rather straightforward example, and I was looking for some curly things here just in case they're hiding something here. I felt that there was no relation. So you have to go to the facts. Okay, mm-hmm. What were the facts? Richard and Katrina really didn't know each other. It's not as if they were married or a couple or anything like that beforehand. And even then, I don't think it would matter that much. They definitely weren't a couple. And that's why I'm saying you've got to go back to the facts and make sure that you're quite aware of the facts. She went in the shop a couple of times, had the first option on some records. She spoke to me and she bought a jukebox. They chatted, go into business, they got someone else. Now, if I was running this case, I'd say to you, there's a lot for this being commercial. Can someone give me, or Debbie, you go ahead, give me a couple of pointers which go towards this being a commercial case?
Firstly, they entered it on the basis that they both had successful businesses and knew how to run a business.
You could get a quarter of a chocolate for that. Next
I'm on a sugar-free week.
Sorry, missed that.
They didn't have a personal relationship apart from a business relationship with each other prior to this agreement.
Yep.
And they brought in a third partner in a partnership agreement whilst they were still not romantic or individuals, but they brought in a third partner under a partnership.
Now, I must admit, I can't recall, it's naughty of me, whether it was a written agreement, because if you have a written agreement, I mean, I'm not saying it's curtains, but it's a pretty strong indicator.
They do say that they understood the need to have their paperwork in order.
Yeah.
Which I infer as a written agreement.
Yeah, and is there anything else? I thought to myself, you could say, reading between the lines, it's important to have a third person there for conflict resolution and stuff like that. But I reckon you've got enough strength there already to show that if you have a choice of a social or a business arrangement, it's a business arrangement. Mm-hmm. And which cases would you refer to? Now, I from having done the class tonight, I know you're not too hot on the names of the cases, but can you give me the facts of the cases? Which cases would you rely on?
Oh, I'm going to have to flip to one of the smart ones.
Okay. Now remember Edwards and Skyways. He was the pilot, and he was given the boot. Mm-hmm. And so you'd say pilot who was dismissed and wanted money. Okay, so Edwards and Skyways, and the Greek bishop.
Church, yeah.
Okay, and you'd rewrite this, and that would give you some nice, really good marks, because ultimately, if you were arguing the case in court, the judge or magistrate, whoever, would want some law behind this, and you'd say, look, based on the authority of such and such, I would submit to you, blah, blah, blah. Okay, so would you think, whoever it is who'd like to mention, would that be different for Emma? Because we've just been talking about, let's say, Richard what about Emma? Would that be the? So if we said that from Richard's viewpoint, it was a business. What about from Emma's viewpoint? The same or different?
Same.
I think the same thing too.
Mm.
Yeah, because she's just an independent person who's come in, and there was very little between Richard and Katrina, and it all gives you the feeling that it was. It just got a strong business feel about it, and I think that's we all agree on that.
Yes, I do.
Good.
Yeah.
Now the presumptions are, if it's social. What was that question we had to ask her in relation to their intention to create legal relations? Well, the presumptions, if it's social, you don't intend to be legally bound. If it's business, the presumption is that the parties intended to be legally bound. Okay, so we got that one. Now the next question we were asked: who will bear the burden of rebutting the presumption? Okay, who will bear the burden? Now, to give you a hand here, I might be wrong on this. So, but even if I'm wrong, the main thing is you walk away from this tutorial and you understand how the presumptions work. Whether it's first of all whether it's commercial or social, then the presumptions and the rebuttal of the presumption. They're the three real things you need to learn about tonight, as well as a little bit on government and preliminary contracts. But I thought to myself, well, you got to think about who's going to be suing whom. Who do you reckon? Who's suing whom?
Richard and Emma suing Katrina.
And what would they say?
Well, they're going to, I guess they're attempting to say that it's not a commercial agreement if they're going to try and kill the contract.
Okay. So Richard and they're going to say what? They're going to say is it a social agreement, or they're going to say it's a business agreement?
They're going to try and attempt to say it's a social agreement, I'd assume.
Well, it doesn't say that. Sorry to interrupt. It doesn't give any indication that they are trying to claim it as a social agreement.
Yeah,
no,
exactly. But that's the only way they could kill it, though. They couldn't kill it on a commercial agreement.
Mm.
And that's a really good point. But the question asks us who will bear the burden of rebutting the presumption. Now, what we've got to work out is who's suing whom. And what I did is I actually worked on the alternative, is that Richard and Emma sue Katrina, or alternative if Katrina sues the other two, because the other two, Richard and Emma, might decide, oh look, we're not interested anymore, and just walk away. And then Katrina says, well, hang on, we got a contract here. You can't walk away. So we got to look at it from both viewpoints, and that's why I had to think about this afternoon and how tricky it is, because if you just do one of them, you may not have looked at the situation properly. So someone mentioned if Richard and Emma sue, they want it to be a social domestic. They want ultimately to be treated as no intention to be legally bound. And how do you do that? Well, you say it's a social domestic agreement which is not rebutted. Agree with that?
Yes.
And therefore, Katrina has the burden to rebut that. So it's a little bit of a tricky question here. You got to work out who's alleging what. If Richard and Emma allege that it's a business agreement which has been rebutted, which makes it non-business, because they are rebutting it, they have the onus of proof. In other words, they have the burden of proof. Okay? So it's straightforward. Whoever does the rebutting must prove their case. Everyone see that?
Mm-hmm.
Okay. So And I again couldn't separate Richard and Emma. They all look pretty much the same to me. Now, what we're going to do, we're going to be a little bit careful here. The choice of whether it's social or business is on an objective test. Now, come on, someone remind me. What does that mean in plain English?
What a reasonable person would think.
Beautiful. As long as they know the facts, how would they see the agreement? And that is the same thing. That's for the first step, social business, and for the rebutting is how they would see whether it's been rebutted or not. Okay? Now, the next one was, is the contract jurisdiction? So, is it subject to going to court? And so I think on an objective basis, just looking at the facts, and as I think it was Debbie or someone said before, it's pretty plain, in my opinion, on the facts that it's a commercial agreement that has not been rebutted. Therefore, therefore you can sue on it. How do we tell if it's been rebutted? Well, you need an honour clause. Did anyone see an honour clause?
No.
No, I didn't see an honour clause.
I also see that everybody's maintained their individual businesses. There's been no pooling of businesses with the commencement of the relationship.
Good point.
So that stood out to me more that it was a commercial contract.
Yeah, three independent business people joining forces to create a business, and it doesn't matter if they get married and have 27 kids.
Oh, God help them.
And that precedes it, and that's that.
Mm-hmm.
Well, they won't have much time to work with all those kids there. But let's get back to the question, Debbie. Quarter of a chocolate for you. I think you were one who was on a diet or something. You said you didn't.
Yeah.
A virtual chocolate to you, because I like what you said about the pooling of the businesses. No pooling of the businesses. See, what you need to do, the judge or the adjudicator, whether it's a tribunal, a county, a magistrate, county court judge, etc., they need evidence, and you need to be pretty clear with the evidence, and it's going to be pretty simple so they can understand it, not too complicated. Put it forward, and that's one I didn't see it, and it was a good one there. Okay, so whether it's whether it's we can fight that in court. Yes, I definitely do see it. Therefore, the Richard and Emma will not be able to get out of it because there is a contract right from the very beginning. Now, Part D suggest arguments against my position. Well, the position of it's a commercial term. It's a commercial agreement. What will Richard and Emma say? Well, they'll say it's a commercial agreement which hasn't been rebutted, or a commercial agreement that has been rebutted. That's what they'll say. And Katrina will say the absolute opposite. It's a commercial agreement which hasn't been rebutted, and a social agreement and is rebutted. But if you go through the whole lot, and if you read the materials, they say something very, very sensible. They say, look, if the whole thing is pretty obvious, it's obvious it's a business. Why even bother going any further? But I wouldn't want to go into court hanging my hat on that. I'd like to do a bit of detective work and be ready. If the judge says, well, look, I reckon it could be this. What do you think? Or the other side brings something up. So you should prepare it at least anyway. But I reckon it's a good, strong case for there being a business. And unless I missed the point somewhere, I don't think Emma is any different from Richard. What do you guys think?
I agree.
I think Emma would be the stronger client to have because she, well, to our knowledge, not had a personal relationship with Katrina.
Yeah.
So, that's the easier client out of the three to have. But overall, they're all equal partners in a partnership business.
But as you and the others have said, is that Richard and Katrina, although they had a relationship, it was all happened after signature, and prior to signature, it was only an acquaintance at the most, and so therefore, although Emma is the least had the least amount of relationship with them, there was a very, very little relationship between Richard and Katrina. So I reckon it's all pretty straightforward in this case, you know. But you've got to be super careful. I had to read this a couple of times to make sure I haven't forgotten anything, and just do the same thing too. And I just remind you when you go back to your when you do your big assignments and things like that, just read, underline, understand the facts. Examiners have a habit of putting little things in. I think last week we had something about 2 weeks, didn't we? She had a 2-week period before she decided to get out of the contract. You know, what was the ratification? You know, and I had to read the stuff a couple of times, and I said, there's one. There's a little thing put in there. You might even have a question here that would this be any different if Richard and Katrina were a couple right from the start? Would anyone like to have a go at that?
It could be if they'd pooled money together to purchase the business. It depends on what the partnership agreement states.
Yeah, good point. What happens if they had a verbal partnership agreement?
It's very complicated from then. I mean, because as I say, it's a parole evidence, and it starts to become difficult.
Yeah.
Richard would have to prove in this case that he had a partnership agreement by burden of proof of paying 1/3 of the debt, receiving 1/3 of the asset, those kind of things. He would have the burden of proof to prove that partnership that was verbal.
Yeah. And the other thing I was thinking of here is that you got to remember that they, being Richard and Emma, a year later on said, well, hang on, this is not all working out, you know, this is all a bit of a mess. And it was only after things were going downhill that they said they want to get out of it, retrospective to when the signature occurred. Mm-hmm. Is that not ratification itself by hanging around for quite some time? I'll give you an example. I go to a restaurant and the waiter comes out and I eat the meal. He comes out and I say to him, oh, waiter, there was a fly in my soup. And he says, well, why did you eat it then? You know, why didn't you complain when I first brought it out? And the same thing here too. That's another argument you'd have. I don't think Richard and Emma have a very strong case here. Okay. Now, if you were the advocate, being the barrister or solicitor who does work in court, you take them on and you try your best. But you know, you have to advise your clients this may not be a good case here. I just got a couple other notes I've made here. Just a couple other notes.
I've got a question, if I can.
Yeah, please go ahead.
Even if Richard and Katrina were in a relationship, the fact that they've involved Emma turns it into a commercial contract.
Lovely. That's a good point, and I like that. We had that last week with the newspaper case, where the daughter, the granddaughter, alleged that the outsider, it was all a family relationship, and the judge said, well, hang on, as soon as he came along, there was no family relationship anymore. So that's a good point. And these are all the points you need to put in. This is not an exact science. You just got to sit down, think them through. Some points will be stronger than the others, you know. And Virginia's case, I just got some notes. I think we've covered a lot of it. Let me just keep it going. I've just got a note here. If it's obvious that it's a social or commercial agreement, don't get hung up. Just say it's such, and just apply the presumptions and move on. If there's a doubt, use the objective test. so we spoke about the objective test. We spoke about government agreements. We spoke about preliminary agreements. And what have we got here? That's it. All right. And in summary, I just got one of the slides here. The distinction between, we discussed the distinction between subjective and objective tests. We did that. The distinction between justiciable and non-justiciable agreements. We just discussed that. The distinction between social and commercial agreements. And noting that with commercial agreements, we expect them to be enforceable. Okay. And also, notwithstanding the amount, it could be a $2 bucket of chips. And just while you're there, does anyone know why the shuttle blew up in 1985? You know, it went up in the air, kaboom, 7 astronauts were lost. Does anyone know why it went up and blew up?
Yeah, a really small piece came off.
Yeah, an O-ring. Now, I exaggerate when I say this. It's $1 US O-ring caused $1 billion damage. Now, I exaggerate when I say that. But in contracts, the amount is not so relevant. What is relevant is whether it's binding or not. Okay, and you got to remember that. And I do a lot with risk and executives and the contracts and stuff like that. And they say, oh, under 100,000, oh, 150,000, oh, we don't worry about risk, contract risk. Well, I say, well, just remind you, the $1 US O-ring, $1 US O-ring, caused a very substantial amount of damage. Just 30 seconds on this. There's a YouTube clip of this scientist, and he gets the O-ring, and it's like a rubber band. It goes like this, you know, like Arnold Schwarzenegger pulling these chains out, you know. And then he pops it into the ice water for a while. He takes it out and shatters. It was not fit for purpose. Now, what happened? It was a really cold day. It was frosty, and the thing didn't do its job, and causing a very substantial amount of damage. And that's the sort of thing you've got to be aware of, that you can have risks even with small amounts of money. Okay, the presumption that social agreements are not justiciable unless you can rebut by showing the activity really is a commercial, of a commercial nature. The presumption that commercial agreements are justiciable unless you can rebut by showing that there is an honour clause. The fact that agreements with governments are only binding on the government if it is acting in a normal commercial capacity. If acting like a government, like administering policy, then the promise is not justiciable. There we are. Ladies and gents, any other questions?
I actually have quite a few questions.
Quite a few? Oh, I thought I could go home and watch a bit of TV, you know. Daniel, how can I help you?
The first one is, so this week's the tutorial is on pension, but our weekly work is on the next week.
Yes, that's correct.
Correct? Yeah.
Yes.
Is that normal?
When I'm new to CQ, I was given, the professor said to me, this is the way I'm to do it. I'm just following instructions.
Sure.
Yep.
And
next question.
I also missed week's tutorial, but I saw that Michael posted that cash payment and the contract becomes binding. Is that correct?
I'm sorry, I find it very hard to hear you. Can you say that all again?
Sorry. I missed last week's tutorial,
yes.
But I think Michael said that if a juvenile makes a cash payment for a contract, then it becomes binding.
I've gone back to my lecturer on that one to ask them to show me evidence, because it's in our textbook. So I've put it back onto my lecturer.
Okay.
The minor can get out of contracts unless it's a necessary. That's the usual rule.
Okay.
I'm not trying to fob you off. It's in the notes there, and in the the tutorial, just go and watch the tutorial. We went through like we did tonight, but in just in summary, look, I'll give you an example, and I gave this last week. So for those of you here last week, just bear with me. My mentor, he was telling me he came home one night and he saw his daughter sitting at the kitchen table. She had all these cosmetics in her hand, and he said to her, "Darling, what are all these?" And he said, Daddy, I've been reading your law books, and I know now that I don't need to return these cosmetics because I'm under the age of 18. And he said to her two things. The first of all, he said, "I'm so pleased that you're able to understand the law because it's quite complicated." And the second thing is, get that stuff out of here. And what he was talking about, the law and ethics. So we're not talking about ethics in this course here. We're talking about the law here. She didn't have to pay for those cosmetics because she's under the age of 18, unless they are necessary. And necessaries include the accommodation, food, and a career and education and stuff like that. And then the difficult part is we go back through English history because it's all this class, class-based, is that it's a necessary based on your station in life. Okay, so for one person, a Rolls Royce might be necessary, and another person, an iPhone might be necessary. That sort of stuff, you know.
Yeah.
But that's you go to your notes there. It's actually, I have to say, because I've been around a bit, these materials are actually very good. Some of the other unis I've been at, they give you absolutely nothing. And you get these. This is actually very well done. And the reason why this is good is that CQ has so many campuses. It has to make sure there's a standard which goes through the country. And this is really good stuff. So it's not difficult for you to read if you went back to the previous week's guide. Any other questions?
Just the final one is there a date yet for the final to take home exam?
I'm still working on that one. I regret I've just been a bit busy, but that's quite some weeks off. But I'm hoping to finish that in the next week because I have to write it myself, and it takes a lot of brain power to do that. But what I can say is, if you listen into these tutorials, I will only be covering stuff from the tutorials because it'd be absolutely wrong to do that otherwise. When I was, my mentor said to me, because he was an English barrister, and he said to me when he was studying, he actually showed me his books from when he was studying, and he said that every lecture you have, summarize it on one page. If you can't summarize it on one page, you don't understand it. And I suggest to you to sit down tonight or soon while it's fresh in your mind, which I would strongly suggest it's tonight, and make a one-page summary. And therefore, and you keep that. And at the end of the term, you've got 12 pages, and you've got the associated pages underneath where you can get the detail. And then you know that you need to understand how it fits together, because I've been around a long time. I've seen a lot of students, and you get some very bright people, but they can't fit it together. If you want to be successful with this one here, and in the real world as a practitioner, you need to know how it all fits together. Okay? Any other question?
I've got one. Someone asking you, when's we going to get access to the first written assignment? Because it still comes up as not available. And that's due week 7.
That's right. That's what the previous person was just saying to you. Give me a week there. I didn't make myself clear. Give me a week there because I have to write it still.
Okay, sorry. I missed that.
That's okay. It's a good question. It's that I didn't make myself clear. What happens is the faculty have asked me to write. It's going to be quite a long one, and I don't want to just do a quickie. I need to think it through, and I need to actually go through to see what you've done and stuff like that. Any other questions?
Thank you.
Okay.
No, nothing from me.
Nothing. Jade, you've been quiet. I'm sure you're in the background somewhere. Debbie, thank you. You've been very active. I owe you a couple of chocolates. I think Daniel, I owe you some. Michael, I owe you some. And we've only got a small class tonight. We've got 1, 2, 3. Someone else had that. I think they've fled in disgust, you know.
Yeah.
But over the coming weeks, I'll be speaking to you more and more about practical ways. I've got to keep it to the syllabus, but I want to tell you about how it really works, because I was totally fascinated with my mentor. And I said, this elderly British barrister, he used to tell me about the war stories, what he used to do. Fascinating stuff. And I said, man, I just couldn't wait to get to the subjects. And we would talk about them and how Roman history came through and this stuff. It was totally, absolutely fascinating, you know. And I'd like to return the favour to you by giving you some real life stuff. And feel free, and what I would suggest to you is be active. Read the newspapers, watch television, go to the movies. If there's something in relation to contracts, make a note of it. Bring it to the class. Maybe do me a favour by emailing me first, so I don't make a fool of myself and trying to think of an answer. I can think it through. But you say, look, I saw this great movie and there was this incident where this and this happened. You know, can you explain that? Or do you think that would be a good idea to talk about? Something like that, okay? Because that's the real stuff which works. You know? And indeed, you're lucky in this course because you've got the real cases which happened in the past, okay? So unless there's anything else, I'm pretty worn out today. Anything else?
Perfect, thank you.
Michael, it'll still be at 6 o'clock Queensland time next week, won't it?
Whatever time it is today, I'll be doing it next week.
I didn't know if you had to push back because you'd be in Queensland.
Yeah,
so
but it's been advertised for 7 to 8 Melbourne time, which that's 6 to 7, isn't it?
Yes, it is.
Yeah, so it'll be 6 to 7 next week. But at the same time, David, don't confuse me. I've only got a limited amount of brain cells left in my head, you know. Nice to speak to you all. I hope one day to meet you all. But listen, take it easy. Now I have to remember how to do this. I have to click pause or whatever. All right, see you later, everybody, and we'll see you again.
Good night.
Catch you. Bye bye.